Whoa!
I filed my eligible obligation.
What are you talking about? What are you talking about?
I'm talking about an eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. If I hear it again, I'm not going to let you represent yourself. I promise you.
Oh.
That's enough. I don't want to hear another word.
Okay, I'd like to also...
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush.
All right, folks. Today's courtroom meltdown features a sovereign citizen who's staring down the barrel of a potential 30-year sentence and decided not to hire a lawyer. Instead, he took the DIY route, representing himself in what might be one of the riskiest legal moves we've seen. Whether it's blind arrogance or a total lack of concern for the outcome, one thing's for sure: it backfires hard. The judge wastes no time shutting down his pseudo-legal arguments, and from there, the entire hearing unravels into pure chaos. It's one of those moments that makes you wonder, why gamble with your future when the stakes are this high? Drop your thoughts in the comments below. Now, let's break down exactly how this courtroom disaster played out.
All right, Mr. Baker, you're before the court day for your arraignment. And let's see. You're not... Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish
Yes,
to have
sir.
the public defender to represent you?
No, sir. I'm going to represent myself.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
It's honestly baffling to watch someone stare down a 30-year sentence and still cling to a fantasy legal theory like the sovereign citizen playbook, saying, "Yes, sir," while doubling down on arguments that have failed in court time and time again. It's either blind arrogance or total disconnect from reality. These defenses don't just not work. They've been explicitly rejected across courts nationwide. It's one thing to try this nonsense over a parking fine, but when your freedom is on the line, this isn't the time for games. So what's driving him? Is it stubborn pride, some deep-seated mistrust of a system, or a genuine belief in this bogus ideology? Let me know in the comments. I want to hear how you interpret this level of self-sabotage.
Yes, sir.
Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business,
All right. What kind of business?
a cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm gonna ask that you enter a plea at this time.
I'd like to file some motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I enter a plea of not guilty.
Okay. All right, you're filing motions.
Yes, sir.
You have copies for the state.
Yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk.
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
That,
If you're not providing to the state, I'm not going to consider it.
okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation. On the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you.
He just dropped USCA, the United States Code annotated, like he's cracking some secret legal code. But let's be real, he probably has no idea what it actually means. This is classic sovereign citizen behavior, using impressive-sounding legal jargon to try and bulldoze through real consequences. And then there's that bizarre belief in eliminating obligations, as if criminal charges can be waved away like unpaid library fines. Courts have shut this nonsense down over and over again, but some people still act like they've found a cheat code to the justice system. So what's going on here? Is he truly convinced this will work, or is it just smoke and mirrors to stall and confuse the court? Drop your take in the comments. I want to know what you think is really driving this mindset.
He's already entered a not guilty plea. We'll set this for a free trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem. Oh,
That's enough. I don't want to hear another word.
okay. I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him.
Honestly, this judge may have done the guy a massive favor by stepping in. When someone's spouting off debunked legal theories in a serious criminal case, there's only so much the court can tolerate. The judge gave him room, even a chance to reconsider. But when it was clear he wasn't taking it seriously, the judge drew the line. Some people might think it was too harsh, but what's the alternative? Let him waste the court's time and risk his own future just to entertain internet nonsense? No. This wasn't just about courtroom control. It was about protecting the integrity of the process and giving the defendant a shot at real legal help. Sovereign citizen logic doesn't hold up anywhere, especially not in court. The judge showed patience, but also backbone, and frankly, we need more of that. What do you think? Did the judge step in at the right time? Or should it have gone further? Drop your take below. And if you're into these legal breakdowns, don't forget to like and subscribe. See you next time.